Hey guys, welcome back to TDA Talks. We are episode 8. I'm joined by Rex Afrasiabi, the founding principal of New Chapter Legal and Bond Property Lawyers. Rex leads the firm's commercial and litigation team and works across property, franchising, and business law every day. So he sees the legal side of the deals our listeners are doing. The contracts, the disputes, the fine print people skim past. He's also a lecturer, an awards judge, and the resident lawyer on Real Estate Renovators. And he took the scenic route through all of it into the fashion industry, which we'll hear a little bit.
Very scenic.
Which we will discuss a little bit later. Rex, welcome to TDA Talks.
Thank you so much for having me. Thanks for the invite.
How are you today?
I'm good. Monday, it's always a good start to a week.
It is. Welcome. Your career started in law and then you took a detour through the fashion industry, then came back. Do you want to walk us through that a little bit?
Yeah. I don't regret it at all. I think it was an amazing thing to do. I was working at a bigger firm, then got headhunted by a boutique firm in South Yarra. They do 3 people in the BRW Rich 100 list. So it was really high-end work, really great work too, great principal as well. I was much younger back then. I was late 20s, early 30s. Even had blonde hair and blue eye contacts, believe it or not.
No.
I did, unfortunately. Boy bands were cool. I'm not sure if they are anymore. But anyway, and the same building as that law firm was a fashion company. And somehow Friday night drinks turned into a job offer and I joined them as their general manager. Which was really good experience. The fashion company did opticals, sunglasses and optical glasses under license for Sass & Bite, Seafolly, some of the bigger brands, Australian brands. So, a lot of international travel, a lot of travel to Sydney, a lot of working hands-on with the designers, and we rolled out retail stores and manufacturing. It was a really good experience.
Okay, what was your turning point to come back to the real estate realm?
I say ex-wife, but she was lovely and we're still very close friends. My ex-wife didn't like me traveling so much, especially to all these fashion shows and stuff. So she persuaded me to go back into law.
And you're enjoying it at the moment?
Loving law.
What's your favorite thing about it?
I'm entrusted to help people.
Yep.
You're entrusted to help people through. Definitely, when people go see a lawyer, it's normally not a great time or it's uncertain time. Even if they're buying something, it's a bit of uncertainty around it. And we've seen it and experienced it. To guide them through it is a lovely thing. And that gesture and the gratitude you get from it is the most rewarding part of what I do.
100%. And you've said your why is helping people. So how does that actually shape up how you run the firm?
Everything is on helping people first. So that's our firm philosophy, I suppose. And it resonates through my teams. If someone doesn't do what's in the best interest of the client or what's in the best interest to help them, it doesn't resonate with our team and we normally have to have a talk to them. Which is fine. It's always at the start. When they first start with us, they don't know how we operate. Some firms operate on billable hours and stuff like that. We generally just want to help them. And sometimes going the legal path is not the best thing for the client.
Agreed. And sometimes you probably want to avoid that.
You do.
Yeah. So I guess we'll kind of go into a little bit more into the property and the investing side of things. So what investors sign without reading, where deals go wrong, disputes that you see over and over. So what's the most common legal mistake you see property buyers and investors make?
Biggest mistake any property buyer, whether you're a seasoned veteran or your first home buyer, you should definitely get your contract of sale checked over. My why is to help people. I've got a national law firm called Bond Property Lawyers. We do it for free. So no obligation, no red tape. We do it for free. Send it to us. We'll have it back to you. At least you get a proper review. It's that little bit of my why resonates through my firm. So we want, and there's stuff in any contract that you may not be aware of, and that's when you can get tripped over.
Yeah, 100%, especially if you just want to kind of sign the deal. And
we have 24 to 48 hour turnarounds. Depends on the size of the contract or which stage it is, but maximum 48 hours.
What's kind of the biggest mistake that you see come out of that?
There's so much that they're unaware of. So if you're buying a property to develop and there's a covenant on it that you can't do to more than one dwelling, well, the whole purpose is gone. If you're buying an apartment or something with an owner's corporation and you haven't read the owner's corporation notes that says in the future we're going to repaint the whole building and it's going to cost an extra 50 grand on every lot owner, that's something you should be aware of. And you can use that when you're in negotiation and go, hey, in a year or two, there's going to be a $50,000 levy. We need to negotiate the price.
And at what point in kind of the property process should someone get a lawyer involved in?
Outset, right at the outset. Before you sign a contract, get that reviewed. There's always something in every contract that should have an expert review. As I said, it's complimentary, no obligation. So, use my team. It's no problem.
Especially with the quick turnaround time as well. You get your
Exactly.
answer when you need it.
Yeah.
You act for estate agents as well. What does the agent side see that buyers never do?
Agents are very different to buyers, I suppose. Well, there's buyers advocates that's similar, but agents act for the vendor. So their job is to get the best price for the vendor. That a vendor's estate agent.
And have you ever seen a deal fall over something that a 5-minute legal review would have caught?
So many times.
Yeah.
So many times. And covenants are a very common example. A covenant is a restriction on a title. It's written in very old English because they're sometimes quite old covenants, and people don't look at it. People don't read it in detail, and they're like, well, I didn't know this restriction was on there. And it could be simple as you can't put it has to be a brick house, or you can't dig on it, or you can't put more than one dwelling on it. Whatever the covenant is, you need to know that's the restriction on it. And so that development analogy I provided earlier, if you're buying up a lot to develop it, you don't realize there's a single dwelling covenant on it, which means you can't put more than one house on it. You're going to get yourself in trouble.
Do you have any stories that you can kind of walk us through where that's sort of happened?
Many. We have a litigation team that for property transactions, so many across the country. It's even on advertising. So I always suggest that whoever's buying something, make sure you take screenshots of the advertising as well, because if something's advertised and it's not what you got in the end, you can use that to get damages.
And I guess when we go into franchise agreements, the franchising code, what intending franchisees miss. So as Australia's first ever tax depreciation franchise, this lands directly with our audience and our network as well. Mm-hmm. So franchising is one of your core practice areas. What's inside a franchise agreement that first-time franchisees consistently underestimate?
The franchise agreement, the whole franchising code is done to protect franchisees. So there's a lot of documents you have to give a franchisee. One is an information brochure that talks about what franchising is. Another is a copy of the franchising code. The third document, one of the most important documents, I believe, is not the franchise agreement, it's the franchise disclosure document. The franchise disclosure document should be read in detail. It gives you the whole history of the franchise, who the owners are, what their history is, what their experience is. It also has to give you how many franchisees there are, their contact details, if any franchisee has left that franchise, all that intimate detail that, in my opinion to them, is call some of these franchisees. See what their experience is with the franchise, or if someone's left, call the ones that have left as well and say, why did you leave? Because you can do your own due diligence on it. The franchise agreement itself is a final document that's in it. It's always one-sided. Reading a franchise agreement is a bit scary because it's done to protect not just the franchisor, but every single franchisee, because you don't want a rogue franchisee damaging everyone's reputation and name. Yeah. But you also want to make sure that whatever is in there is relatively ascertainable. So if there's KPIs on it that are, beyond reasoned, you want to have some sort of negotiation tool on it and be reasonable. There should be minimum stuff, not maximum stuff, just in case there's a change in market or whatever the case happens.
And what questions should someone ask the franchisor before they sign anything?
I don't know look, the support, the initial cost, getting the documents, I think doing your own due diligence and asking third parties is better off, in my opinion, than asking the franchisor. But speaking to other franchisees, speaking to potentially ex-franchisees, you're going to get a very different view of the franchise than if you speak to the franchisor who may just be selling you the franchise.
Yeah, 100%. And is there any telltale signs to a good franchisor versus a bad franchisor?
Yeah, the disclosure document.
Yeah.
If you look at the disclosure document and you've seen so many movement within franchises very quickly, or they've started litigation proceedings against any of the franchisees, alarm bells should be ringing. If it's like one litigation over, X period of time, doesn't matter. But if there's like multiple litigations, the disclosure document disclose how many times have the franchisor sued any franchisee. That information kind of should ring alarm bells.
And is there a specific time in which they should be run before someone kind of looks at it and goes, this is a good idea? Or is it sometimes the best idea is the fresh idea?
I don't think it makes a difference on the length of a franchise, truthfully. I think it's the disclosure document talks about the history of the franchisor and their core people. Looking at that is more important, in my opinion. See what runs they've got on under their belt, not what they've done as a franchise. Because the best franchises sometimes, they all started with no franchisees at some stage.
Yeah.
And getting in early is always a good thing, not a bad thing. So, but looking at the history is really important.
And from the franchisor side, what separates a well-built franchise system legally from one that's headed for trouble?
The support they give. So a franchise is not just a brand, in my opinion, it's a whole system. And the system and processes they have, which is to support their franchisees to succeed. So, the more support a franchisor can give to their franchisees, they become your raving fans. They're the ones that are going to help you grow it. If you don't give them much support and just take their fees, they're gonna leave you at some stage.
And what kind of causes that breakdown in a relationship that you've seen?
I think greed, unfortunately. A very public case at the moment is 7-Eleven. 7-Eleven was sold to new owners who've been very greedy and kicking out all their franchisees, take the stores for nothing. And it's been all over current affair and news and stuff because of how harsh they've been. And just greed. 7-Eleven wasn't run like that until the new owners got in my opinion.
And how long does a process like that take then?
In what way?
So I guess from the initial breakdown to then seeing it all fall apart.
Look, there's processes in the franchising code for mediation and the like. So it can happen really quickly, or it can go through the mediation process. We've had few examples of franchisors terminating without cause, and we've had to get injunction applications to get it back on foot, etc. So, it really depends on how it goes.
And I guess with, you've mentioned a few times that you lead a litigation team as well, but a lot of your value seems to be keeping people out of litigation. Is that fair to say?
I do lead a litigation team, and I take every single client. No one wins by going to court but the lawyers. That being said, sometimes you have no choice but to start proceedings to make sure, to show people you're serious about something. Most of my cases, if not 98%, which is nearly all of them, will always settle before a court hearing, a final hearing. Doesn't mean we don't start court proceedings, doesn't mean we don't process it to advance our position, but if you're going to go make a demand and say, if you don't pay us or if you don't do this, we're going to have to go to court. If you don't go to court to enforce it, it's like if you can't make a threat and go through with it, don't make the threat.
And what's one dispute, I guess, that's stuck with you and really helped your business grow from the lessons you've learned from that?
Partnership agreements, shareholder agreements, unit holders, depends on your structure. A lot of disputes happen with business partners internally, and that's because they don't have a solid foundation. I think the biggest thing I would recommend anyone starting a business, or even if you're in a business having it re-looked at, have a look at what your core partnership agreements are with your business partners. It may not be called a partnership because shareholders, for companies, it's a shareholders agreement, if it's a unit trust, a unit holders agreement, but it's effectively your partnership agreement. It governs your relationship. And a lot of ones we've seen, unfortunately, have not been tailored for the partnership. They're kind of generic documents that doesn't really apply to them. So, there should be, most partnerships should have very strict decision-making processes in place where, and I normally refer to money. So if you're making a decision up to $10,000, one person can make it 10 to 50, two people, 50 plus. Like, you just put ton of frameworks around the decision-making, distribution policies where you don't want your partner saying, I want a distribution every month or every week. It's quarterly, biannually, annually, whatever the case may be. You want to, in that distribution policy, embed some sort of retained earnings to pay for working capital and keeping the lights on. You don't want everyone to draw all the money out. And then if something goes wrong, they're the most important stuff, and going detail about things that can go wrong. Most of them just go, if someone goes insolvent, you're out. That's not enough. What if someone's done something inappropriate at the office and touched someone? What if someone is going for family court proceedings? The biggest issue in any family court proceedings is business. Properties, cash at back, shares, they're easy to value. But But when you hear these nasty stories that go on for years of disputes, it's because they can't agree on the value of a business. Now, if your business partner is going for a divorce, you want to support him. But if you're giving monthly accounts and bank statements and everything to, it just takes resources away from him. But if you can quantify that and saying, if you go for a divorce, I can buy you out at this agreed price. He or she can take it to their ex-partner and go, if you don't agree with this, I'm being bought out.
Yeah.
And once it buys out, there's no question about valuation. It is that.
And at what point do you decide whether you keep fighting or you stop fighting?
You can't, once you start proceedings, you can't just stop fighting. You can always settle, and we always do settle. You always try to go for more than what you're going to accept and come back to what you're going to accept and realize there's a cost to it, but you're better off doing this than walking away getting nothing.
Yeah. Has there been kind of a time in your career where you've just not been, I guess, happy with the outcome?
Many times, unfortunately. Not so much. Look, I'm only here to help and assist the client.
Yeah.
But sometimes you've got a strong case, you go to a mediation or something, you've prepared your client saying, this is what we should go for and stuff. And then you hold them, they just get scared of the situation and they accept something for a lot less than they should have. And you're like, it's done. And then they go, oh, why did we do that? I'm like, I told you not to do it. But then.
And how do you then tell them something they don't want to hear?
I'm very direct.
Yeah.
I don't hold stuff back. So, I give them my opinion, but I'm there to help them. So if they want to make that decision, I'm there to help them. I don't, my opinion is not going to sway how I help them.
Yeah. So pretty straightforward.
I think you need to be. You can't sugarcoat something in any part of your life.
Yeah. True. I agree. I guess back to, lessons from your career and how it's kind of ended up. So what did the fashion industry teach you that law school never could?
My role at the fashion company, apart from how to dress and but my role was a general manager. So I was running that business. It was it's international company that I was running. So as a lawyer, you see aspects of disputes or commercial negotiations. You don't get to run. You can run a law firm, and I do, but it's not run an international business. And the different restraints and resources and decision making that goes inside a business has really helped me understand and help clients better as a lawyer.
And you're known for saying you won't be outworked. You've even got the tattoo.
I do.
Where does that drive come from?
I'm very competitive by nature, not in a bad way, but anything that I do, I like to just even create competition in my own head to make me push myself harder. So I do have that tattoo, and even at my, I'm old now, but I still try to if I'm at the gym or anything at all, or playing any sport, I'm always the last to give up.
How old were you when you got that tattoo?
In my 20s. I'm in my late 40s now, so a while ago.
So you still stick by it? Still stick by it,
100%.
Where does the next chapter look like for New Chapter Legal and Bond Property?
We're in a really interesting growth phase at the moment, which has been lovely. Bond Property Lawyers wants to become a market leader in property transactions across Australia. It's a massive industry. It's a $2.2 billion industry. In every other service industry, there's a market leader. Chemists, you can think of Chemist Warehouse. Any other service industry is a market leader. In conveyancing of property transactions, there isn't. We've got a national firm that can service every single state. We've also got exclusive agreements with two ASX-listed companies, the agency and AFG, which is the second largest mortgage aggregator in Australia. Even Aussie Home Loans got an exclusive agreement, and many others. And that's going to help us grow. The firm's only 3 years old now, and we're already national. We're already getting that market share. So I want to make it a 10 to 20% market share in that space.
And from where you sit, how often do the legal and financial sides of property deal talk to each other? Things like structure, tax position, depreciation.
I think they should talk to each other every day.
Yeah.
It's so important. It depends on which we look at. Even if you're a home buyer, you need to get your finances in line, unless you pay by cash. Not many people pay by cash. But if you're an investor, you need your depreciation schedules. You need all that to be able to get the maximum tax advantages of this.
Are you getting people asking you about what these I guess, the new budget changes look like, and are they seeking legal advice on what that looks
They're not necessarily seeking legal advice. They're seeking more legal opinions, or my opinion on it. I'm not sure if it's legal or not. I think it's more of an accounting issue. Look, changes are going to happen. Government, you can't control government, especially this one. But changes are going to happen, and I don't think you should sit there, in my opinion, and go, "Oh, it's all over, doom and gloom." Just adapt. The ones that adapt quickly and move forward are the ones that will succeed, in my opinion. Look, yes, they've taken away negative gearing, for example, but that doesn't mean that's only on existing residential. You can still negative gear on new residential, which has got better tax savings anyway, and commercial property. Yes, they've taken away SMSF borrowing on residential, but they haven't taken on commercial. Yes, they've put taxes on family trust, but they've also allowed you to restructure, to make it a company with a trust underneath or something like that. That's what I'll be doing myself and advising my clients. So there's ways to quickly adapt, get used to the new norm and move forward. To sit there and dwell on it, you're just going to get worse into a hole or fall further behind the people that have adapted and move forward.
100%. I agree. We'll go into some rapid fire questions.
Oh, okay.
What is the biggest legal myth in property?
All contracts are the same. It's a standard contract, just sign it.
Yeah.
Agents or someone that always says, "Oh, it's a standard contract, just sign it." No.
What does that even mean?
Well, the contract could be standard, but the in Victoria, for example, there's a vendor statement that has all this disclosure information. The contract could be standard. It may not be any special conditions, but it doesn't negate from what's in this vendor statement.
Yeah. And one clause everyone should read twice before signing anything.
All clauses. But if it's a standard, like for example, most real estates in most states have a standard form contract where it's kind of legislated by government. But there's special conditions. So if you're buying real estate, you don't necessarily need to look at the standard form contract, but read those special conditions.
And what's the best piece of advice you've ever been given?
The lion doesn't care about the opinion of sheep. Like, people are always going to talk, but you can't ever please the masses or anyone else. It's hard to please yourself and your close ones. Just focus on that.
Rex, if you could leave listeners with one piece of advice about protecting themselves legally in property or business, what would it be?
If it's property, reach out to my firm. If you're buying a property, get a free contract review just to make sure you know what you're signing. If it's business, review your partnership agreements. Make sure the biggest disputes are normally internal.
And for our listeners, if you mention the keyword objection when you book with TDA, you'll receive a $50 discount on your next tax depreciation.
Objection?
Yeah.
Why objection?
I wanted it to be, I don't know, a fun legal word.
Fair enough.
Do you have another
No,
fun
I like
legal
objection.
word?
I'm just surprised. I thought it was part of TDA, but part of this. Okay.
Yeah, we wanted to make it a bit fun, get them actually listening. If they hear it, they hear objection, they know that's what's going to get them the discount for their report.
Awesome.
Perfect. Well, thank you, Rex, for coming on and speaking to us here at TDA headquarters, actually. And I hope you enjoy the rest of your day, and I hope that our listeners really got something out of today, because I know I did.
Thank you so much for having me.
Thank you.